the first to know. Nsem-Pii TV.
Yediani Chilemu ewa the Criminal Division of the Accra High Court. And the court of Sitra, the case involving Nsem-Pii Ato Forson, Sylvester Enimana, Richard Japka, and a Big C General Trading Limited. A ambulance scandal involved 2.37 million euro. Now, the last time I court to court Asitrano, the Chief Justice received a petition from the lawyers of Richard Japka. Petition in the Richard Japka lawyers SCK said the Chief Justice Gertrude Tukono, only presiding judge, ya oti case in so, ya your Justice Efia Sewa Asari Bochi, and free case in so entirely. Now, one cofa obifu from Fademra. Now, the lawyers of Richard Japka reasons are almost 30 was application in the say. Among said trial judge, ya your friend Justice Efia Sewa Asari Bochi. In fact, were your bias. And then the matter judge your bias. Richard Japka lawyers say Justice Efia Asari Bochi, Emma or my client Richard Japka stand warning or court. Said in some hunu. Said be when mama me did no court to be. Now and now sir stand a instruction. Justice Efia Asari Bochi de ma Richard Japka I say or ya your bias. Ya no person wo ye na odi omu etum. Now what is the basis of the trial judge giving Richard Japka a stern warning? Emra cross-examination between the Attorney General Godfrey Yabadame and Afeyura Alex Mood Ukosuno and Richard Japka echo Justice Efia Sewa Asari Bochi one say be Junso Deno to pese Okogunsu. And the presiding judge catch say within the court premises what room or hono entino obetumi akwa ye no hu ye wo Richard Japka dwa so on the opeso kwa ye no hu ye wo abonten that is kasa kasa eho enema the trial judge Justice Efia Sewa Asari Bochi ede one man say court ha de say be untumi man na medi mrento asem eno and the lawyers gina so say the judge is becoming biased eno ntino the Chief Justice Gertrude Tukono enyina so na onfa en remove no en free case so now anopai omukopie mu e wo court ansana proceedings kra no e ba be hyase o ene case no ena Justice Sewa Asari Bochi and notify the two parties, that is law counsel for Richard Japka, counsel for Nsem-Pii Ato Forson say petition ya no almost seeking for the transfer of the case from no Justice Efia Asari Bochi no. In fact, ruling from the Chief Justice about Bontin. Now ruling is say Chief Justice abosa application no atuogu say eye frivolous enyina so bia eni. Now Justice Efia Asari Bochi this answer to January no. And after lawyers for Nsem-Pii Ato Forson and so filing two motions. Now, one of the motion and said the presiding judge, Justice Efia Asari Bochi, should recuse herself. And a motion number 2 and say the court should release the passport of Nsem-Pii Ato Forson. Now, omonfa emano. And the first motion for the presiding judge to recuse herself for the releasing of the travel passport to Nsem-Pii Ato Forson. Justice Efia Asari Bochi say after the cross-examination and obe examine that motion no say is it right to release the passport of Dr. Nsem-Pii Ato Forson to him or it is not right. Now, presiding judge Emma Kwan say the Attorney General able to me across examine the first defense witness for Dr. Nsem-Pii Ato Forson. Alex Mood, who happens to be the former Chief Executive Officer at the Ghana National Petroleum Corporation. Now, in fact, cross-examination so interesting. Very, very interesting. One, Godfrey Yabadame put two. Yewra Alex Mood say, Ojitum say, 2 letters of credit were issued from the Bank of Ghana by the authority of the Controller and Accountant General under the signature of Nsem-Pii Ato Forson. Sir Enko Big C General Trading Limited for the first consignment of 50 ambulances. Yewra Alex Mood ejitum say no credit. These two letters of credit were released. Now, the Attorney General Sampututu, Yewra Alex Mood say, those letters of credit, ojitum say, nipa na nsasase, the Deputy Finance Minister, Dr. Kesel Ato Forson and Yewra Alex Mood ejitum sampa, ono the signature and chassis. And Alex Mood bechitum say, ono the onim, Minister, Deputy Minister, Ejuma Yemuni say, in such contracts, most of the times, the substantive minister and a authorization for payments to be made. And you know, if any payments are made under the signature of the deputy minister, or no Alex Moden himself, under the jurisdiction of Sadi and Yamasi Yajman, Emrebiana, the substantive minister, and a authorization to the deputy minister say, onye bibi on behalf of ono. Ena Yewra Godfrey Yabodami Ebusa Alex Mode say, our document be a HRS say the substantive minister and a man authorization for Dr. Kesel Ato Forson to issue those letters of credit and Yewra Alex Mode say there is no documenter HRS say the substantive minister did, who was then the Minister of Finance. Yewra said tekpe krata bia ne ho ana document bia no HRS say ono and the man Yewra Kesel Ato Forson to me say on issue those letters of credit. And Yewra Godfrey Dame sign putu to Alex Mode say ojitum say those letters of credit at that time issued by the Deputy Finance Minister Kesel Ato Forson resulted in payment of over 2 million euro to Big C General Trading Limited in Dubai for the shipment of those 40 ambulances. And Alex Mode Jitumu say it is true. Say those two letters of credit a result to in payment of monies to Big C General Trading Limited. But also Kabie say if any payment is made by a ministry or not the when you say anything, none, and I said nothing of such payment can be made. Emra, the substantive minister, any hungry. Also, that is how it works. Payments cannot be made from a ministry to an international corporation or an international company. Emra, the substantive minister, any hungry. Only the no. But on to me, said that the document to be the honor na authorize Dr. Kesel Ato Forson. Oriana no say put to Yewra Alex Mode say, ojitum say reporter, the health minister, obeji ejano, Yewra Alex Sebefi to one say those 50 ambulances were defective and not fit for purpose. And now Yewra Alex Mode say he came across such a report by the then health minister Alex Sebefi say those 50 vehicles are not fit for purpose to serve as an ambulance. Again, now a defective. In fact, cross-examination so heated. And what the criminal division of the Accra High Court. And one, Richard Japka lawyers petition you to command the Chief Justice for the removal of Justice Efia Serebotwe because Omofili said she is becoming biased. Chief Justice Botugu is a frivolous. Two, motions Dr. Kesel Ato Forson lawyers filing and so Ankwan Kusiaga. Three, the cross-examination is becoming very interesting. Now, the best work, we will not hesitate to bring to the doorsteps of Nsem-Pii at year 4. Now, I was a from us.
That says that his trial is a witch hunt, and he has asked the judge to recuse herself for alleged bias. What's your comment on that?
Yes, last time we were in court, the judge said that a petition had been sent to the CJ. The petition was filed by I think Sedu. No, the other person with him. I think one of the other accused, but the minority leader has also filed a motion. Tomorrow will be the day that will be in court. We don't know whether the CJ has reacted to that petition. So depending on what the CJ says, then we may want to know what we have to do. But nobody is persecuting him. In actual fact, his case started last year in court. And I have to commend his lawyers also. the state has been able to we called about 5 witnesses and close our case. They've even opened their case and called 2 or 3 witnesses. So it's not about persecution, it's about rule of law. If at the end of the day, the court comes to a conclusion or determination that Ato Forson is not guilty, so be it, that's rule of law. If the court says he's guilty, that is it. So there's no inclination on our part to persecute him, no.
What about Collins Dauda?
His case also in court today or yesterday. The prosecutors went to court. The case will be starting in November. I understand. Here will be starting in November.
There's a view that there are so many cases that could have piqued the interest of the government, which would probably involve MPP officials, but you have not thought it wise to persecute any of them. So the NDC, indeed, they released a statement a couple of days ago, basically saying that the MPP was witch hunting their members.
If they can cite examples, I'll be happy. If, for example, they can show Mr. A or Madam B was alleged to have done ABC, the state has not taken any step, then we'll be entering the healthy debate. But if you just put it there without any basis, then responding to such a statement will be a bit difficult for me.
But you understand that the Kwesi trial particularly is affecting the work of Parliament because of their boycott.
I don't understand. You see, why didn't they boycott when their leader, not leader, was undergoing prosecution last year up to this time? Mr. Collins Dauda, alleged Collins Dauda, his case started 2 years ago. He's been coming to court all this while. Why did they boycott?
Because they are saying that having done a by-election and having gotten the mandate of the people to now bring a case of perjury is a stretch. They feel that you are trying to use the courts to redesign the balance of Parliament.
You see, that argument is very weak and cannot hold water. Unless they are suggesting that if you are a citizen, you commit an offense, you're able to go to elections and win, because of that you should not be prosecuted, then I will agree with them. Because this gentleman was undergoing prosecution before he won the by-elections. And so if we are going to use elections as insurance against prosecution, that will set a very dangerous precedent.
But you took him on a different case. Initially it was about his qualification, Nsem-Pii and co, that he wasn't qualified. But from the record, it's quite clear that having started the election, as of the time he was voted for, he had the documents. But because of the technicality of the time he did the filing, he was thrown out. So to now have him win the election and then go and now say that he perjured the court, it's in whose interest? What are you trying to achieve with that?
This prosecution started in January 2022. When did we have the by-election? Just about a month ago. So if the case had been that after the by-election we are not bringing more charges against him, then this argument may hold. In any event, if you take the charge sheet, we have 5 counts or 5 offenses. The first 2 offenses have nothing to do with elections. It's about the time that he applied for a Ghanaian passport, somewhere in July 2019. He had not even applied to renounce, where he filled a form and allegedly indicated that he didn't have dual citizenship. Mm-hmm. He did this before a public officer. So what offense has he committed? We may want to press charges of deceit of public officer and also trying the offense relating to his deception when it comes to the acquisition of the passport. So these 2 offenses have nothing to do with elections. Unless people are saying that so far as he has won elections, we should forget about it. That I said, in that case, the gentleman who's also saying, someone may say, oh, now that I've gone to rape this lady, let me just go to my people, win elections, and they use that one as an insurance against prosecution. In that case, Ghana will not be going anywhere.
Final one is Opuni. So initially there was a judge who said that this matter has to be retried from the beginning. You vehemently disagreed with that. In fact, your boss criticized that judgment. I don't want to use the words they used. Now you have your way because the old matter. What is your expected timeline? Where is this case in this running?
Yes, this case, we were in court yesterday, I think yesterday. The judge has agreed to adopt the orders of the Court of Appeal. But Dr. Opuni and the other people, they've also appealed against the decision of the Court of Appeal. So even if we start, and the Supreme Court says that no, the Court of Appeal erred, then that you have to come back. That's how law works. And so anytime I see that people may want to take advantage of the law, even though it may go against me, I still say, fine, that's the way that the person wants it to go. Let's meet the person in court.
So law teaches